Justice Barrett, Justice Jackson.
So I guess I'm trying to understand the basis for our being able to determine that the district court in this case erred, which is what I understand you to be asking us to do. So are you saying that Alabama has selected any one of those 5 methods by legislation, for example, and the district court refused to apply it in its consideration?
No, Alabama hasn't adopted one of those.
All right, so you explored a number of possibilities with Justice Kavanaugh, none of which Alabama has actually adopted, so we can't say that the district court erred by not applying Alabama law in that sense. Did you ask the district court to apply any of those methods in its consideration of this defendant's intellectual disability?
Well, it's the petitioner's burden to come in.
No. Did you? Your burden right now as petitioner is to establish that the district court erred. And so what I'm trying to ask you is whether you are saying that the district court erred by not evaluating this defendant in a way that he was never asked to do by the state below.
Well, it's a legal error because my answers to Justice Kavanaugh were that those are all reasonably reliable methods that the state could adopt. And if that's true, then it doesn't matter whether Alabama has in fact adopted them in statute because there's no Eighth Amendment violation.
That was my first question. Doesn't it matter for the purpose of our evaluation of the district court's error whether or not the district court was asked to evaluate this defendant using the method that you now say it was erroneous for the district court to not have used? I mean, this never came up during, like, no one said to the district court, please evaluate him using this method, and the district court said no. In that situation, we then assess whether the district court was wrong in refusing to adopt that method.
We didn't get that far because we had 5 IQ scores that clearly show he loses, and then the district court focused only on the 72. And so the question—
The district court was weighing all of the evidence under the standard that it seems like your expert also agreed was the right legal test at the time. And now you're saying the test should have been different. The district court was only allowed to look at one of these other 5 reliable methods, although no one said to the district court at the time, please look at that method.
We said to the district court, Alabama law is a true IQ of 70 or below by a preponderance, and then the district court did not apply that burden.
Okay, let me ask you this, because I do think that there's something about party presentation here that's a little troublesome. A couple weeks ago in a case called Clark versus Sweeney, we summarily reversed a grant of habeas because the Court of Appeals had granted habeas based on an argument that the petitioner had not presented. So I feel like you're actually asking us to violate that same principle. You never asked the Court of Appeals in this case, for example, to evaluate the district court on the basis of these 5 methods and say that it was erroneous on that basis or on the cumulative effects test. I'm a little confused all around because I thought the question presented in this case was about the cumulative effects test and that that's what you were actually advocating for, but that didn't come up in the lower courts. So how could we possibly reverse on the basis of these kinds of arguments that were not presented below?
We absolutely did present evidence from Dr. King at JA 270 and 271 that his consistent scores were above 70. We didn't have to get to the level of granularity of specifying a particular method because there is no method in this case that can prove his IQ is likely 70 or below. We're offering those to answer the court's question how to assess multiple IQ scores.
And
but
your answer is not something about cumulative effects is what the court had to do and didn't do. I thought that was the test that you were requiring us to consider as the thing that a district court has to do.
Our first argument is that it didn't do that because it looked only at the possibility. And if the court agrees it has to do that—
Wait, I'm sorry. I thought you were saying the district court erred because it didn't consider the cumulative effect of multiple IQ scores and that the cumulative effect was a thing that the district court didn't do. All I'm asking here is, did you ask the district court to do that? Or did you say to the Court of Appeals the district court has erred because it didn't look at the, quote, cumulative effect of the multiple IQ scores?
Yes, we said that in the district court with Dr. King's testimony. We said
Cumulative effect. I'll find it in the record, because I didn't see the words cumulative effect in the record.
Well, there are lots of synonyms, but consistent scores above 70, that's the same thing. And then the 11th Circuit, we presented this evidence and said the district court didn't take seriously the whole of the IQ evidence because it didn't even mention his score of 78. So it couldn't have done the cumulative effect. That's enough to reverse. If the court wants to go further and discuss the reasonably reliable methods, we think that would be a good idea, especially for guidance.
So you're not asking necessarily for that rule about the reasonably reliable methods that certainly did not come up before?
Well, that is the question presented. And so that would be a complete answer to Smith's claim, is that there is no way that he can prove an IQ below 70, because even on these common and expert-approved methods, he hasn't shown that his IQ is below 70.
Thank you.
Thank you.